To further discuss this, I am joined by a legal practitioner, managing associate, Copley Partners, Okiki Adeniran. Good morning, Okiki, and thank you so much for joining me this morning.
Good morning. Thank you for having me.
Okay, now we'll take a look at two of the most recent judgments of the Court of Appeal on the governorship election. And, let's begin with Benue State, where the court held that the issue of certificate forgery was a pre-election matter. Now, if the suit touches on the basic qualification of a candidate who is now an office holder, should there be a limitation to when such a suit should be brought before the court?
Yes, there should be a limitation. As you speak, there's a limitation to when issues like that should be brought to the court. And this is the reason. This is because if there's no limitation, we find out that there will be a lot of suits in court. And in fact, to go ahead with the election itself will be very difficult. However, there should be an exception. Now, an exception in the sense that where the general rule is that there should be a time limit, then in cases where we have we have cases such as forgery, maybe anything criminal, I believe that the court should be able to take that and move further with that. For example, just like you've mentioned, forgery, the one that was alleged in Benue State. In that case, it should be that the court should be able to look into the case and not just put it aside based on the fact that the case is probably started bad. It was supposed to have been heard at pre-election stage, but it was not. I believe that for justice to be done, such should be done. Such case should be heard.
Okay, okay. Now let's move away from Benue State now to Plateau State. Now, the Court of Appeal gave the appellant the leeway to get involved in how the candidate of another party emerged, whereas there are a number of judgments that suggest that the emergence of a candidate is the reserved business of the political party and also its members. Now, do you see any inconsistency here, and what do you make of this whole, scenario?
Yeah, I do see inconsistency in this. Actually, that I'll say that I've experienced this. I was in a case just some months ago, a pre-election case, where we were told by the court that we're Medusa Interloper, we were not supposed to be in the case, and as a matter of fact, that the case was started bad. The issue in Plateau, just going by what the court delivered, the judgment the court delivered. Section 177 of the Constitution, the court relied on that. And more specifically, the court talked about the fact that the sponsorship and the nomination of the candidates was questionable. For that, I believe it's a pre-election matter. Just like I mentioned, there's a particular time frame for pre-election matters to be heard. And in that case, if the court is coming to probably just say something about a pre-election matter at this stage, then there's an inconsistency. You cannot appropriate and reprobate at the same time and say, oh, this is at this time, it's a pre-election matter, and when you feel that it's you want to judge in another manner, you say, oh, okay, you can judge and say that this person was not nominated. Nominations and sponsorship are pre-election matters. They are not matters that should be brought to the tribunal. They are not matters that should be taken to the appeal court after an election. It's not a post-election issue.
All right, so now you talked about, some of these issues being a pre-election matter. Well, a lot of people are actually of the school of thought that governors should not be sacked, that after they actually sworn in and, they've been into office and they've started work and all that. Now, would love for you to tell us, what do you make of the opinion that sacking these governors should only be exercised in rare and exceptional circumstances, or valid and compelling reasons, for valid and compelling reasons? Is this the case in, let's say, Kano State, Plateau State? And also, while you're still thinking about that, is there a procedure by which the judiciary can review some of these actions without parties necessarily appealing? Is it possible?
Well, I'll start from a way the judiciary can review these positions without appealing.
Yeah, please.
Now, cases are supposed to be brought to court. When you are supposed to seek redress from court, you're supposed to bring issues, facts before the court and document before the court to, prove whatever you feel that the court should judge. So in this case, you know, the court will only rely on whatever has been brought to it. You know, so just as it lies on parties to still come to court to come and appeal. The court itself cannot, you know, raise issues by itself and also be a judge. You can't be a judge in your own case, like the Latin maxim says. You know, so it's the duty of parties to come to court, appeal to court, to let the court know these are the issues I have regarding a judgment, and this is what I feel it should be. And then the court looks at it and takes a decision based on that.
Okay. Now, before we let you go, Okiki, are you concerned that the power of determining who governs a state or even holds other selective or elective positions seems to be shifting from the people to the court?
Well, I'll say that that's not the case. Now, if we look at it clearly, it starts with the people. Now, the elections were held in March. People voted, February and March, people voted. And it was as a result of this that parties decided to approach the court. You know, so it's still based on the decision of people that the court will work on. You know, if there's no court for people to seek redress, for parties to seek redress, then there will be anarchy. So in this case, the court will only judge, like I said, based on what has been brought to it and based on what is in the law. However, just like I've mentioned in this interview, there are cases where there are inconsistencies, and that is why we have levels of courts. As it is, the parties aggrieved at the appeal court can go to Supreme Court to go and seek redress. So as it is, it's still...
So the people you're talking about in this case are the political parties and not the masses, right?
Yes, the parties, the political parties, yes. The political parties, I mean. So as it is in this case, political parties can approach the court, you know, and seek redress from the court and get judgment. However, I believe that, you know, recently, because of some of the cases the judgment we've been hearing and we're getting from the court, some parties or some citizens are not they're not sure of what political parties will get from the court, the judgment they will get from the courts. But the fact still remains that the court is the court. The law is the law. Whatever the court says, you know, is binding. And I believe that when such is done, just like it happened at the Presidential Tribunal and it got to Supreme Court, when the decision was made, you know, the only thing to do is to adhere to what the court has said. So to cap it all, it's basically the citizen, the people, and also the courts. Whatever it starts on the people, and then it goes to the courts. As a matter of fact, you will agree with me that we cannot say that because we expect, or there's like, let's say, a massive support in that sense, as it is, just in quotes, by probably mentioning of names or people following probably social media. We cannot say that based on that we can agree that a particular candidate should be in a particular position. The court looks at everything holistically and takes a decision. So it starts with the people and hence with the court. And most importantly, the court is allowed. The court is a place to seek redress. And in case there's an aggrieved party, such party can, you know, move forward and get justice.
All right. Thank you so much, Okiki Adeniran, for your expert's view on this.
Thank you for having me.